because I'm tweeting this, and if people want to join, great. Okay. Hi, everyone. We are super casual right now. I had just emailed the Texas County Clerk's office, and I got some filings that I was not expecting today. So I wanted to hop on and do this live with Jarrett. He was in the middle of something, and I was all over the place. But I'm just tweeting something out right now, and I'm going to upload some of the documents here so Jarrett can go over them. I want to be sensitive about this. I've already had some time to digest. So I don't know. I was not ready for this when I got them. Let me just put it that way. So, all right, hang on 1 second. I'm trying to get everything together. Okay. Sorry, now I see myself on YouTube and it's echoing.
So basically, Lauren, while you're prepping that, I just want to
Yes.
note, like, as these pretrial filings keep happening, you're going to find inserted in the filings more details that are unavoidable and have to come out because the details are important. What's that?
Sorry, I'm like, these are so bad when you read them.
Yeah, it's awful. It's awful. So what's going to happen, and that's what's going to start happening even in the Kohlberger case and things of that nature, when the prosecution holds investigative details close to the vest, as you get through these preliminary filings, there are details that are relevant to the legal positions being taken. So basically where we're at today is, as we discussed in our last video, there are arguments being made by certain defendants in the Kansas Moms case saying the preliminary hearings should be separated, that they should not be heard together. And today, the state has responded to that position saying, wait a minute, you entered into a conspiracy, lock, stock, and barrel moved together in furtherance of killing Jilian and Veronica. And here is exactly what the state's theory is, that your particular role in bringing about the death and the burial was. And when you lay those facts out and you lay them over one another, you have a very clear, very graphic, extremely violent picture of what happened to Veronica and Jilian and how this conspiracy is starting to fit together. Now, it's not the whole story, but it is the portions of the story. It's the portions of the story that are relevant to rebutting the contentions that the defenses are taking. And some defendants have agreed we could do this preliminary hearing together. We covered that. Some are fighting it. So in response, here's basically what was filed.
Can I ask you something really quick? When it says facts on these documents, why are they allowed to say that they're facts exactly? When this is just based on what they gathered evidence-wise and confessions and I guess
first of all, these are the facts as the state sees them and as they claim they've occurred and they believe they can prove. They are facts gleaned from their interviews and things of that nature. So when a document is broken down in that manner, they're typically broken down facts, procedural history, legal argument, things of that nature. So it doesn't necessarily mean every fact is true and will ultimately be proven. I suspect in this case and hope that they can prove these facts, but really it doesn't mean they're established in the court.
Yeah. Okay. Just making sure, because I was like, okay, this is interesting. I guess I don't see a lot of briefs with facts on them, but I haven't seen nearly half as many briefs as you have. So, okay, let's I guess we can go through this. So I feel like kind of guilty reading this. I feel weird, but I think it's important because it's vicious. And I think that this is why the death penalty is on the table, Jarrett. But it says that Tad Cullum, Tiffany Adams, Cole, and Cora Twombly, and I'll paraphrase a bit, they all entered into an agreement, a conspiracy, and planned the murders of Veronica Butler and Jilian Kelley. And this is exactly what you said. Cole and Cora, in part, were the lookouts on the day of the murders. And in furtherance to the conspiracy, they confided in their daughter in hope of receiving an alibi for the murders. Okay. Now, this is the tough part. Grice, in part stabbed and killed Veronica Butler, and he sliced his hand badly with the knife and accompanied the bodies of Butler and Kelley to the burial site. He threw in his clothing, stun gun, the knife that used to kill her in the burial site, and his clothing was found in the burial site, and it contained Veronica's DNA, his clothing. And I just want to point out that Veronica is a badass. You know that she fought so hard, and that is why that moron cut his hand, most likely.
Well, and I can tell you this too. So looking at that now, okay, this is the first time we're learning this publicly, that Paul Grice was injured in the stabbing.
No, we knew he was injured. He wrapped his hand and had like this nasty injury that he said, what did he say? Remember, he said he was working. This was a lot. Listen, it's been a lot. Like he said he heard it working on his fence, and then he told someone else his car, whatever. This is
okay. So let's take what is alleged in that particular paragraph.
Mm-hmm.
My experience has been an individual who sustains an injury like that in a stabbing is engaging in multiple stabbings. That comes from when your hand slips on the knife.
Okay.
So it's typically a multiple stabbing situation. Again, that's not in the document. I am speculating. And then when he throws his clothing, stun device, and the knife all into the burial, the hope on their part is those bodies remain in that burial site undiscovered for all time, and there will be no weapon found, and their clothing is not found. Okay. But when defendants and killers do that sort of thing and leave certain articles with the body, you can tie that back, and the burial site contained Grice's DNA. Now, he is officially tied through DNA, through clothing, through the weapon, through his injury. So the noose is getting tighter around Paul Grice. So it's significant. And of course, he made a statement to the investigators initially as well. So again, there is some good news here. You have to realize, Lauren, as these facts are being put forward, they also are clearly able to be established. So that is some good news for the families and people watching. Know that as unpleasant as this is, there are components of this that are important and will ultimately help on the road toward what we all hope is a conviction. Okay.
All right. Well, I feel a little better with you saying that. So I'll continue. And then it says Cullum, in part, got permission from the landowners. We know that he rented the land to dig the hole for the burial site. I don't know if they're saying that the landowners knew about it being a burial site. In the other affidavits, they said that he did not. He had no idea, and he kind of felt like he was played a little bit almost. But he dug the hole with his skid steer the day before the murders. He stabbed and killed Jilian Kelley and drove the bodies of Butler and Kelley to the burial site. He put his clothing in the burial site and buried Butler and Kelley inside a freezer in the previously dug hole. His clothing found at the burial site contained his and Kelley's DNA. The accessories to the knife found at the burial site were found in his home. Can I ask you, would there be another charge of him transporting the bodies, or... Well,
there's typically here in Pennsylvania, we have an abusive corpse charge, things of that nature. But at this point, that's just piling it on. In that if there is a charge of that nature, you can get that in, but it's all coming in anyway. But let's break down his role here.
Okay.
If you look at Cullum's, the facts as alleged against Cullum here, he's securing permission from Beasley, right? That was the guy that owned the property. Yep. He's securing permission at a minimum to access the property and work there with a skid steer, okay? But that shows the level of planning that went into these particular killings, okay? So he's getting access to a site to dispose of the bodies. He is alleged to have stabbed and killed Kelley and then transported the bodies to the site. He, in addition to Paul, put his clothing into the burial site and buried it with them. His and Kelley's DNA are found there. Now, of course, Kelley's DNA is going to be there. Her body's there. But again, the noose is tightening against Tad Cullum here because now His DNA is mixed in with Kelley. So you're putting a circumstantial case together, a scientific case together. The words of the defendants are supporting the evidence that's being found at the burial site. So all of that is very important and showing the level of interplay between the co-conspirators. Grice helped in the stabbing. Grice dumped his clothes in the burial site. Cullum arranged to get the burial site. Cullum transported the bodies to the site. Cullum dumps his clothes, like Paul, into the burial site. He stabbed in part with Grice. So what I like to do is weave all those facts together. It's like you lay these facts out individually, and then you just draw all these connections on how it was all in furtherance of the conspiracy.
Can I also ask you this? And I don't know how to say it exactly, but if let's say you brought up abuse of a corpse, if there are any signs that they did anything to them after, could that come out later and maybe the state holds that evidence and doesn't charge them?
Just transporting a dead body in a vehicle and dumping the body into a hole in and of itself can be abuse of corpse. So
do you think another charge is coming possibly? Because
no, you wouldn't charge that separately. If they're bringing it, they bring it under this information and the facts that are already known. I mean, they could add that if it's not already there.
So you don't think more charges will be coming?
No, that would be it's a lesser charge. So you wouldn't bring a lesser charge on another information. This is all part of these particular circumstances. So if when I don't believe that has been charged.
No, it hasn't. It's just murders, kidnapping, and conspiracy. I guess I was just curious because I know in the Corey Richins case, they added charges after. Karen Reed, they added charges after. And I wasn't.
You can add it. You can add that lesser charge later. When I hear you say, are there more charges coming? I'm like, are they going to be rearrested on new charges? This would be a lesser. This would be a lesser graded charge related to the big picture. It could be added in.
Okay, so it could be added in, which I hope it is. I mean, I just want anything to be thrown at them at this point after reading this. So then it goes on to Tiffany Adams, and it says Adams in part purchased the burner phones from Walmart, which were used by the conspirators to communicate. She purchased the devices at Standard Supply, or the stun devices at Standard Supply. One of the stun devices was found in the burial site. She purchased the yellow straps that were placed around the freezer containing the bodies of Butler and Kelley at Tractor Supply. She purchased the pants that Cullum put in the burial site. Adams hated and despised Butler and wanted her dead. Pursuant to the plan and conspiracy, each defendant did their part to aid and abet in the murders of Butler and Kelley. So then you have the argument in support of the Joinder hearing. So basically it says, and there's a lot of case law cited, but when defendants participate in the same criminal act, there is no authority in Oklahoma authorizing or mandating a separate preliminary hearing for each defendant.
Which all the defendants agree. If you remember, they were arguing federal law in support of separating them. But let's take a look at what they said Tiffany did. If you could go back to the previous.
Oh, yes.
Game.
Yes. Sorry.
So the allegation, we broke down Paul, we broke down Tad. Let's talk about Tiffany.
Yeah.
Tiffany is said to have procured certain tools necessary to effectuate the conspiracy. In a conspiracy, you have to communicate in a manner in which you believe is not traceable. So she procures the phones. She procures the stun guns, which it's believed were used to incapacitate Jilian and Veronica on their way to what ultimately would be their deaths. Then she is also claimed to have bought the straps that held the freezer shut. Mm-hmm. So this is, again, there's portions of what she's accused of doing before the killing and things that would aid in the burial. So Adams's role, as we all know, is from soup to nuts from the beginning of this conspiracy to the end. And you can bet the evidence they have is video of her buying those straps at Tractor Supply or a receipt, hopefully photographic evidence of those things. But again, all of this paints a picture of these folks working together, acquiring materials, buying the phones, buying the straps, setting the table for what Tad and Paul eventually carried out. which was the stabbings themselves.
And from what I've gathered, Jarrett, just from my research and locals and anyone that is somewhat connected to the case, it really does sound like Paul could be easily manipulated, and Tad and Tiffany are very big manipulators, and it really seems to show. I think that, I'm thinking about Cole and Cora, and I've spent a good amount of time on Cole's Facebook, and clearly, look, they're all evil. There's no denying that. If all of what they allege is true, yeah, they're evil. But it does kind of make sense to me that Cole and Cora did not act out any of this rage and act on the murders, I guess, if that makes sense. And I'm not excusing them at all, but I guess it's just sort of all clicking in my mind now that I kind of can see who did what.
Well, again, we can only base on what's out there, and in this particular document, there are no now. The fact that they diverted them is significant. Okay, that's part of the allegation.
They're evil. They're despicable.
So they basically again created a situation that allowed for Jilian and Veronica and kicked this whole chain of events. Essentially, if you do an affirmative, overt act like that, you are essentially responsible for the entirety of the conspiracy, which means the murders, the burials, etc. Now, are they less culpable in the sense that, as of this document, they're not accused of actually committing the murders?
Right.
Okay,
right.
So you have accomplice and principal roles here to a lesser degree. The Twombly's aren't implicated in this particular filing with killing anyone with their own hands. That being said, I have repeatedly gone on record on our show and said I would be approaching them to talk to them about possibly entering into an agreement with the state and testifying.
Oh, so do you think that, and have you done this in any of your filings where maybe you hold off on, like maybe Cora and Cole did more, or no? Would it pretty much come out in this filing, do you think, or have you kind of staggered this type of information?
No, I mean, I wouldn't be soft soaping their role with the hope that they become a witness for me. I mean, look.
Yeah.
Right. I would, and the point of this entire filing is to show the level with which they were working as one together. So if the Twomblys did things that contributed to the conspiracy as a whole, you can bet I would put all of it in this particular filing to make that point. And then any subsequent filing in support of those charges. So I wouldn't hold off. And all that's going to come out. I mean, the theory is, you're going to have, whether or not one of these individuals becomes a witness, their role is going to have to be made clear. You can't clean that up. You may make them presentable for court. You may help them prepare for testimony, but you have to be honest about their particular role in the conspiracy, in the killing. You can't soft soap that, because quite honestly, you're lying to the jury at that point. And they could be left confused and miss something and then say, hey, it's not clear what happened here. So it's everybody, all facts on the table. If somebody comes to the table and wants to plead, then you deal with the facts as they're dealt to you.
Okay. And sorry, since I had this zoomed in so I could read, I'm looking at the chat really quick. Sorry guys, I didn't see the chat because I was zoomed in on this. But let me just go through. Okay. I'm looking at some of the comments. Hi, Run for Justice. Hi, Disney. Hi, Taryn. Hi, Meg. Hi, Gretchen. Okay. I've noticed a lot of states I've watched trials have the similar abuse of a corpse charge. Okay. Yeah, that makes sense. I don't know if anyone else is as shocked as I am to see these documents. I just know I got them. I requested them thinking it would be just the state's argument, blah, 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 standard. And I actually, Dizzy, is Dizzy on here? I forwarded it to Dizzy for the Discord server. And then I opened it up to read it. And then I was like, oh my gosh, I just forwarded it without even giving her a warning here. But let me go back really quick, Jarrett. So, okay. So the case law that they're citing, I think did you say it was federal or?
No, the case law that one of the
Okay.
defendants, when you said there's no clear case law entitling
Yeah.
them to separate preliminary hearings, it was one of the defendants had argued some federal case law. And in our last video, you asked me why would they argue federal case law? In the face of no state law supporting their position, federal case law would be persuasive authority to the court. This thing's going to be held together. It's going to be held together.
Okay. All right. Well, so then my last thing I kind of want to bring up to you is just speaking to some of the locals in town, and there's a lot of rumors. And from what I'm hearing, this is not the full scope of everything. Fine, I'm not going to say more than that. I don't want to spread any rumors, but I think this rumor, this one in particular, is interesting, where people are hearing that there could be a chance that the suspects are released on bail pending trial.
Yeah, I'd have to look at the bail rules in Oklahoma. I mean, bail rules differ in every state. You can recall, like Karen Reed was out on bail pending her charges.
Right, and she had murder too, but this seems to be. Let me see bail laws in Oklahoma.
I believe they're entitled to bail in Oklahoma.
Here, I'm just gonna. You know what? I put. If you guys, did you see my Did anyone see that? Okay, yeah. If you guys, I'm going to remove these docs so I can share something else. Look at the chat, you guys. I put my link if you want to review the documents from my Pop Crime TV blog. But
well, let me say this. In Pennsylvania, homicide is a non-bailable offense. So anyone charged with homicide sits and awaits their fate in a court.
Okay.
In the event that it is a bailable offense in Oklahoma or anywhere, the considerations that have to be made. Number one, people have a right to bail pre-trial, okay? But there are it's not an unlimited right. If there are indications that any of these individuals are going to take flight, for example, I think it was the Twombly's that packed a go bag. I kind of remember, but yeah. Anything of that nature where you would say, Judge, these folks are going to take off. This is going to be, let me just plug in my computer. Hang on. So those are factors you have to consider in basically assessing whether or not someone is entitled to bail. That's number one. If someone suffers from a drug addiction, for example, and releasing them out into the street poses a danger to themselves and others, that's another consideration. The nature of the charges themselves, the fact that this was a significantly long conspiracy that spanned several weeks, months, the fact that the nature of the crime is so serious, all of that gets considered in establishing bail or refusing to establish bail. So if there's a rumor that these individuals are going to get bail, I am sure the state is going to oppose it on the grounds of the nature of the offense, the risk of these folks fleeing the jurisdiction, and things of that nature, intimidating witnesses, things of that nature.
Yeah, this one says following an arrest for a misdemeanor or felony offense and before formal charges have been filed or an indictment made, the arrested person may have bail set by the court. B, when formal charges or an indictment has been filed, bail shall be set according to law and pretrial bond, if any, may be reaffirmed unless additional security is required. Every judicial district may, upon the order of the presiding judge for the district, establish a pretrial bail schedule for felony or misdemeanor offenses, except for traffic offenses. What? Title 20. Those offenses. Okay. It doesn't really say. Are you able to see that? I'm not finding like.
Yeah, but we're assuming for the purposes of our conversation, if it's allowed, the arguments the state would make. But we can double check on that.
So, but here's the thing: a judge would have to say, "Oh yeah, that makes sense, guys. You're right. Like go out into the world until you're trying." I don't think a judge would do that in this case.
Well, you would hope, and if they do it, they could be subject to house arrest or electronic monitoring, things of that nature. So again, if it's a right in Oklahoma, it's a constitutional right. It's a right to bail.
That doesn't mean it's happening, Jarrett, right?
It doesn't. No, it doesn't if there are sufficient reasons put forth to prevent it from happening and the court feels that those reasons are legitimate, they could prevent it.
I'm going to say pending. I'm asking Google something very specific right now. Can you be released on bond pending a murder trial in Oklahoma? It says, yes, a person charged with murder can be released on bond in some cases. However, it's rare, not guaranteed. The Tulsa County District Court preset bond schedule has a 0 next to the charge of first-degree murder, and it means the law allows judges to withhold bond for those. Okay, so yeah, I mean, where it's allowed, like you said, you're right, it's allowed, but it says everywhere judges obviously make the final decision.
Right. They have the discretion. So all of those arguments in the event that there is anybody asking for bail in this case will be made to rebut them getting out. So, and ultimately it's up to the judge if it's allowed in this particular case.
So I want to clarify that for anyone that's local. In the state of, like Jarrett said, in Pennsylvania, the law is you're not, if you have a murder charge, you cannot be granted bail or post bond before your trial. In Oklahoma, it's a different law. You could, but it's up to the judge. And in this case, I mean, Jarrett, would you,
based on your Google search,
shut up. No, literally, but I'm just saying, in your experience, these 5, no, they're not going to be granted bail.
I wouldn't anticipate that based on the nature of this crime.
Okay. Yeah. I'm with you on that. Okay. And then there was one other thing. It was just the state's response to the defendant's objection to civil forfeiture of evidence and order of the sale for the evidence, which this was basically, I'll just read this really fast. It says, the examining magistrate in Texas County has no jurisdiction to intervene, modify, or overrule orders of the district judge in the following civil forfeitures in Cimarron County. And this is what we discussed the other day, the trucks. And it says the defendant has failed to provide any authority for the exercise of such judicial power. The court issued an order dated the 15th of May that provided in part the following: the state of Oklahoma or any agent of the state of Oklahoma shall not release any evidence or items related to those cases which are currently in the possession of law enforcement. The state intends to use best efforts to comply with the court's orders. Absent court approval, the state will not release or otherwise dispose of the property that is subject matter of the above referenced civil forfeitures filed in Cimarron County, Oklahoma, until the above captioned matters have been concluded.
Okay, so that means all of the things we talked about, which is the truck that they forfeited and the skid steer are not going to be sold off prior to the defense, at a minimum, having an opportunity to inspect, photograph, test. Mm-hmm. And they're saying, even though we've moved forward on forfeiture, nothing's going to happen until the case is concluded, which is the right answer. So that is, from the defendant's perspective, they're getting what they want. Okay. And then there's some discussion about jurisdiction between civil forfeiture law and the criminal courts, which is a little bit of a heady conversation. The bottom line is that evidence is not going to be gotten rid of prior to the defense having an opportunity to review it and this case even going to trial. So it looks like they're just moving forward on the forfeiture process. In the event the trial is ultimately concluded, they can dispose of the property as they see fit. They'll have the authority to do it.
Okay. Run for justice. I saw, so Jarrett and I did a video the other day about Cole and Paul and Tad wanting, or basically Cole and Paul being okay with having their hearings together in December and Tad not being okay with it. No, and so, but we didn't go over Tiffany and Cora because they had not posted yet, but I just got those filings actually like a second ago. So we'll go through those, but yes, it looks like Cora and Tiffany filed motions to hold the preliminary hearing separately. I mean, why would Cole and Cora have such opposing views on this? I wonder.
It's a strategy. The lawyers are saying there's no case law. The ones that have agreed are just saying, really, there's no downside to this as we see it. There's no case law justifying them not being held. They're going to be held together. This is like
Yeah.
You know, I get lawyers and respect the fact that they have to do their job. But the reality is, looking at this, looking at the facts, looking at the nature of the conspiracy as alleged, there is no prejudice to any of them holding just a preliminary hearing together at this point under the Joinder rule in Oklahoma. So I think the two that have agreed already basically threw their hands up and said, there's no real downside to this. If they're going to hold them together, it's basically, it's a nullity.
Okay. And the state said, each piece of evidence will be separate per defendant. If it's for that defendant, we will make sure of it. And I'm sure their lawyers, the defense attorneys, will be all over that to object.
Well, remember, it's a judge that makes the decision at this stage, not a jury. So a judge is trained in the law, can differentiate, okay, this is a particular piece of evidence against Tad. This is a particular piece of evidence against Paul. I mean, there's not 100 defendants. You could look at this and say, hey, I mean, square peg, square hole. I mean, that's basically how it's done. And again, I've had multiple defendant hearings where at the end, you're given an opportunity to do a closing or a summation, and you would lay it out against each defendant because you're responding to each of their lawyers. You would say, okay, let's talk about Mr. Grice. And I would just bang, 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 every little piece of evidence that I have.
Yeah. Okay.
And then, obviously then go on to Tad and Tiffany and everybody else. So, and a judge can do that. I mean, it's almost insulting to say a judge couldn't do it, which is why those two agreed. Not to say those other lawyers are wrong for asking for it. They're not. They're doing their job.
Okay. I guess what can you say at this point to just put people at ease that are locals, that are dealing with this and hearing this, and, family members? I just, I feel so bad for everybody with all the rumors and people just being nervous, thinking that there is a possibility of them getting out on bail. I mean, it breaks my heart. Like, what do you say to them?
Well, the only thing I would say is that there are, I've fought for victims throughout my career. There are guardrails in the system that would protect individuals from these folks just walking out of there footloose and fancy free, irresponsible of their obligations to the court. So that's one thing I would say. I would say that, the court is not powerless. They're not just going to walk out the door.
Yeah.
And I would also say, looking at this documentation, the state has a very, very compelling and strong case against these co-conspirators. So the road to justice isn't always pretty and it's never quick, but as this moves forward, it's clear the state knows what happened here and they believe they can prove.
And I think it's important to note that, we've discussed this, the state works for the people as well. And the people in town and in these areas are like, absolutely not. We are just heartbroken. We are disturbed. We are petrified. Can you imagine what the people would do if they were let out on bail? I mean, that would be failing the people 100%. I feel like the state would not be doing their job at all if they were let out on bail until the trial. I mean,
again, all those things we talked about are going to be very heavily considered by the court, and I don't anticipate bail being granted.
So are you badass in openings and closings, Jarrett, in court?
I don't know. I think there's some reports of that stuff online. You could check it out. I wouldn't want to toot my own horn. So there's some of that out there.
You're funny. No, I wish I could have seen you in action. I wish I could have, but well, there's always a chance of you becoming a defense attorney in your life.
Oh God, Jarrett. I don't know. We'll see what the future holds, right?
Yeah, we'll see. Well, guys, like I said, we wanted to jump on. I was in shock over this, and I was just disturbed to my core, and I was not expecting this. So I hit Jarrett up. I made a blog post.
It's a significant development. And, our goal with our show is certainly to inform and to entertain. But when you talk about things like this, and we know people close to the case are watching, like, our heart goes out to you. This stuff isn't easy. You need to prepare yourself for some of the harsh realities that are going to come out in these proceedings and know that it's for really, in the end, to get justice. So be patient and find a way to endure this.
Yeah, absolutely. You nailed it. I mean, I'm sure that people close are watching, and our heart goes out to you guys. And like I said, you know where to find me, and I know where to find Jarrett. So if you ever have questions or you need anything clarified, just let me know, and I'll check with the big guy over here, because he's the one that knows everything. So
you're right.
no, but like I said, I did break this down a bit. And if you want the actual filing, the link is posted right there. I put it on the Pop Crime TV blog. So check that out. Use your discretion. It is disturbing. But all right, guys, check out our show tonight. We'll be back live at 8 p.m. And I'm so glad, Disney, that you think this is helpful. But yeah, tonight, 8 p.m., we'll have Mizzy Berry, who runs the Justice for Sandra page, and she does all of the amazing things for Sandra Birchmore. We'll be discussing that case and the new filings from Matthew Farwell, as well as the filings from Michael Proctor and his cell phone. And then, of course, Sarah Boone, because Jarrett has never given his thoughts on Sarah Boone, and I am so excited for his thoughts. So, all right. Yeah, catch us tonight, 8 p.m. Thanks, everybody. Thanks, Jarrett.
Thank you.